Emergency provisions. National emergency, Article 352. Emergency provisions. Article 352 to 360 of the Indian Constitution deals with the provisions, rules related to the emergency, that enable the central government to meet any abnormal situation effectively. In a certain situation, to safeguard the sovereignty, unity, integrity, and security of the country and the democratic system of the Constitution, the President of India can declare an emergency, based on certain situations. Under an emergency situation, the President can overrule certain provisions of the Constitution including fundamental rights. Emergency provisions alter the power structure. Under this, central government becomes all-powerful and converts the federal structure into the unitary one without any formal amendment to the Constitution. Emergency provisions. Types of emergency. National emergency, Article 352. President's rule, Article 356. Financial emergency, Article 360. For the first time, the President's rule was imposed in Punjab in 1951 and the national emergency is declared 3 times so far in 1962, 1971 and 1975. National emergency, Article 352. When the ground of emergency is war, external aggression, and armed rebellion, it is known as national emergency. Note: due to the vagueness of the term internal disturbance, 44th Amendment Act 1978 substituted it with armed rebellion. National emergency is also categorized into 2 parts. One includes the declaration of emergency on the ground of war or external aggression, it is known as external emergency. Other on the ground of armed rebellion, known as internal emergency. National emergency can be applied to the entire country or to any part of the country. Limiting the operation to any part of the country is enabled by the 42nd Amendment Act 1976. Declaration of national emergency. National emergency can be declared by President only, after receiving a written recommendation from the Cabinet. Approval of national emergency. Both Houses of Parliament are required to pass the proclamation of emergency with a special majority within 1 month from its issue date. Special majority: a majority of the total membership of the House and a majority of not less than 2/3 of members of the House present and voting. Note: 38th Amendment Act 1975 made the declaration of national emergency immune from judicial review. 44th Amendment Act 1978 deleted the above provision. Minerva Mills case: Supreme Court made it clear that the national emergency can be challenged in a court. Can be challenged on what grounds? Malified or not reasonable, or declaration is based on irrelevant facts. How long a national emergency can be in force? After its approval by both Houses of Parliament and declaration by the President, it continues for 6 months at a time and can be extended to an indefinite period with parliamentary approval every 6 months. Note: periodic parliamentary approval added by the 44th Amendment Act 1978. Revocation of national emergency. With a subsequent proclamation, the President can revoke the emergency if only Lok Sabha passes a resolution disapproving its continuation with a simple majority. Effect of national emergency. The Centre become empowered to direct the state regarding the manner in which executive power is to be exercised. The Centre become entitled to give executive directions to the state on any matter, which means, though the state governments are not suspended, they come under the ambit or complete control of the central government. Though the legislative power of state government is not suspended, Parliament gets overriding power and is empowered to make law on any subject mentioned in the state list. Highlight: the law made by Parliament on state subjects during the national emergency will become inoperative 6 months after the revocation of the emergency. If Parliament is not in session, the President is also empowered to issue ordinances over state subjects. President will be empowered to modify the revenue distribution between the Centre and the states. Parliament is also empowered to extend the normal tenure of the state legislative assembly by 1 year at a time. National emergency's impact on fundamental rights. Article 358. It deals with the suspension of fundamental rights guaranteed under Article 19 of the Constitution. As per Article 358, under the emergency provision, Article 19 is automatically suspended when the proclamation of emergency is made, i.e., it does not require any separate order of suspension. Condition: there is one condition. Article 358 comes under the role only when external emergency is operational. That clearly means that Article 19 is suspended only when there is an external emergency and not an internal emergency. Article 359, it deals with the suspension of other fundamental rights except for Articles 20 and 21. It requires a separate order for suspension, and only those fundamental rights are suspended that are mentioned under the presidential order. Such an order of suspension of fundamental rights requires the approval of Parliament. The suspension could be for the duration of the emergency or could be for a shorter duration. 44th Amendment Act 1978 says President cannot suspend the right to move to court for the enforcement of fundamental rights under Article 20, protection in respect of conviction of offense, and Article 21, right to life and personal liberty. Thank you.